We'll go ahead and get started. My name is Brant Hellwig. I'm a member of the tax faculty here at NYU, and I also have the privilege of serving as the faculty director of the graduate tax program. So welcome to the kickoff of Reunion Weekend. For our alums that are back, it's wonderful to have your engagement and to have you back in our classrooms. For the Reunion Weekend, we get things started with the Jerome Manning Tax Salon. This is the 5th installment of the Tax Salon, so we're really excited to have you here for this event. And before I introduce our speaker, I'd like to say just a few words about Jerry Manning, in whose honor his family established this endowed speaker series. So Jerry was a graduate of the NYU Law class of 1952. Shortly after graduating, he joined the law firm of Struck, and Levan, where he specialized in estate and gift taxation and estate planning. Jerry authored the definitive treatise in the field entitled Manning on Estate Planning, and that's published by the Practicing Law Institute and is now in its 7th edition. Jerry contributed significantly to the strength of our graduate tax program at NYU by teaching as an adjunct professor, where he taught for 40 years. And for 25 of those years, he taught the capstone course in estate planning. So we're grateful to members of Jerry's family for the establishment of this Salon series. It's a wonderful vehicle to honor his legacy at NYU Law School, creating an additional avenue for alumni and students to engage with one another through the discussion of current issues in taxation. Now I'd like to introduce our distinguished guest. Megan Brackney is a partner in the law firm of Kostelanetz LLP, practicing here in New York, where she specializes in tax controversy. And she has over 2 decades worth of experience in the field. Megan practices in all aspects of the tax controversy arena, ranging from advising clients with compliance measures and voluntary disclosures, to representing clients in the audit process, including administrative appeals, to litigating cases before the United States Tax Court and federal district courts. Prior to joining Kostelanetz, Megan served as an assistant United States attorney in the Southern District of New York, an office that has a record of producing some of the finest litigators in the country. Megan is a double graduate of the University of Kansas, where she received her undergraduate degree in philosophy before pursuing her JD degree there. And importantly, she is an alumna of the graduate tax program. She pursued her LLM in taxation as a part-time student, receiving that degree in 2009. Megan has made and continues to make considerable contributions to our program here at NYU. She's been something of an anchor of our tax controversy curriculum, teaching our Survey of Tax Procedure course. I'm sure many of our alums are familiar with that 1-credit gem of a course, right? And she also teaches more in-depth courses on tax litigation. Lastly, I should note that Megan currently serves as the chair of the American Bar Association section on taxation. The tax section's got a fantastic annual meeting planned in May in just a couple weeks. So we're certainly fortunate to have one of our graduates and adjunct professors serving in such a significant leadership position in the tax profession. So Megan, thank you very much for being our speaker, and we've got a fantastic talk on tax and ethics, something that it's always nice to have that prize CLE credit, particularly in the ethics realm. And it's a really interesting topic now, more than ever, I think, as we're experiencing diminished resources from the IRS dedicated to enforcement, and that looks like that's only going to continue. So the importance of ethical and professional obligations among the practicing bar, I think, is going to be something really important to kind of preserving the integrity of our tax system. So please join me in welcoming Megan.
All right, thank you. Thank you so much for that nice introduction, and thanks for coming out tonight to listen to a program on ethics. And it does really fill me with a lot of pride to be able to be here at NYU. I did, as Brant mentioned, I took the course as an associate at Kostelanetz part-time at night. And I certainly didn't think when I was grinding through that I was going to be an adjunct professor here or have the opportunity to address all of you in this type of very esteemed format. So thank you for having me. And hopefully we'll have a little bit of fun tonight talking about ethics as well as getting you your CLE credit. So we'll kick it off. And This is kind of a long thing, and I'm not going to read it out loud to you, but it's sort of the theme of the night, and it's a little bit of what Brant just said, which is, as tax practitioners, as tax lawyers, we're really the gatekeepers of the tax system. No one can opt out of the U.S. tax system. Everyone has to participate and file. There's never going to be enough resources to police everybody, and I don't know that we necessarily want to live in a state where everyone is so carefully policed. So instead, what we have is our system of voluntary compliance, and it really relies on all of us to follow the rules, apply the standards, and aspire to meet all of the ethical guidelines so that we can have a workable system. And so that's what we're going to talk about tonight, get into a few specific Circular 230 provisions, and I would love to have feedback from you all as we go. I may ask you some questions. You can ask me some questions. If I talk about something that triggers something in your mind that you want to share about your own experience or question, just jump in. So we'll make this interactive as we can. All right, so when we're thinking, you heard I was a philosophy major, so I can't resist a little bit of this, which is, thinking about like what we're talking about here, the difference between the law, legal rules, and what is allowed. And we're going to talk a little bit about that. And then moral, what we all personally believe to be right and wrong. And then the ethics, which are the rules of professional responsibility that include Circular 230. And that's what we're going to talk about tonight. And one thing before we get into it, this is a framework that we use. And also, I should credit my law partner, Brian Scarlatos, who also is adjunct here and a graduate from this program. Some of these slides might be from Brian, and so I do want to give him credit. And he really is the person I first heard speak about Circular 230 and tax ethics in this framework, where it really helps before you sort of embark on giving advice or working in the tax system, to think about these three things, like the three forces that are always present with us when we're working in the system, which is our own duty to the system, right? To work together to have a fair, efficient, and tax system, with integrity, that. Our duty to the client, right? We have duties under the model rules of professional responsibility to be loyal to our clients and to advocate for them and to try to get the best outcome possible. And then we also have a duty to ourselves to make a decent living, but more importantly, to be able to sleep at night and to not worry about having, the special agents knock at your door, or to be sued for malpractice, or to have an angry client calling because they're under audit and the IRS has said the position you advised on is incorrect and that they're going to be subject to penalties. All of those things are incredibly stressful. Like we've all had, well, I haven't had special agents come to my door and I haven't been sued, but I've definitely had the experience of working with people who, are unhappy if they're being audited, and it's really stressful, right? And so we want to have a framework for how we act that honors each of these three things, which sometimes compete, right? And so that's what's tricky about the ethics rules, is like, how do we act in a way that serves these three goals all the time as best as we can? And Circular 230 actually does a fairly decent job of getting us to that point. So after saying that, I always have to say the next thing, which is, of course, we're not just here to scold everybody, right, for trying to plan transactions in a tax efficient way or give advice to clients in a way that's going to save or eliminate their tax liability legally. So of course, tax planning is legal. We should advocate for our clients. We should get the best outcome for them possible. And if that best outcome is that they pay the least amount of tax that's legally permissible, that is great. There's nothing unethical or improper about that under the rules. Now, before we get into our obligations, I think it's kind of interesting to talk a little bit about the other side of this. Like, what do our clients think about complying with the rules? What pressures are they going to be putting on us to push the envelope? And so the IRS does these taxpayer attitude surveys every couple years, and I don't know if you've ever looked at them, but they're really fascinating. And so I think this is a fun fact, and this is consistent over a very long period of time. 84% of people say it is not at all acceptable to cheat on your income taxes. That is fantastic, right? I mean, that's a really robust system of voluntary compliance, when 84% of people think that they need to pay the correct amount of tax. But what about the other 16%. I mean, it's not a small number of people when you think about the number of taxpayers we have in the United States, including, individual and all of the entities. So what are they up to? What's going on there? And it's really, tonight we're going to kind of talk about the 16%. We don't need to worry about the 84%. They'll take our advice to do the right thing. It's the 16% that's going to push us, right, into the aggressive position or to doing something that we might not be comfortable with. Also, I think that it's interesting to think about why people might not want to be compliant. It's not just necessarily greed or antisocial personality disorder. It could be other things too. And one of a theme afloat these days is the lack of trust in government. And so there are people out there who answer this survey and say that they don't trust the government to spend their tax dollars wisely, or they don't agree with some of the ways that the government is spending our money. So we won't go through all of these. These are just in the deck. If you're interested in looking at this more, you can, to see how these attitudes sort of play out. And also looking at the report online, if you'd like. It is really interesting. So we'll move through those pretty quickly. Just know that they're there to look at what our clients are thinking about when they're talking to us about their tax compliance. Now, I made this slide before April 15th, but have you all heard? Has anyone heard, in social media or around about a tax strike? Yeah? Does anyone know anyone who actually did it that they know of? Okay, so one of my law partners came across this on a Substack post, and this is written by an attorney. And this person is saying, I like my state of Illinois. I will pay my state and local income tax, but I am not going to file and pay my federal income. Well, I don't know about filing. It's a question I would have if I was going to speak to this person. Are you just not going to pay, or are you not going to file and not going to pay? Because there's, some differences there in terms of the outcomes based on that. But this person is saying, who's an attorney, who is apparently now working more as a consultant or on a contract basis, so she doesn't have withholding, or she doesn't have sufficient withholding to cover her taxes, that she's not going to pay her income taxes this year. And for those, I have a couple students here. What's the definition of willfulness? I'm going to call on you in the back of the room because I know you know. I put you on the spot. You're getting there, though. You said intentional. So willfulness is a voluntary and an intentional violation of a known legal duty, right? And that's an element of almost all of the tax crimes. And so that's what you're looking at here, right, is someone who is educated, understands the tax rules, and says, because I don't agree with my government's positions, I'm not going to file, or I'm not going to pay this year. And so, that's out there. People are talking about this. Of course, all of us, if anyone asked any of us, we'd say, that don't be ridiculous. File and pay. You're buying a lot more trouble than you realize. So anyway, I think that's kind of interesting. So just thinking about that. So we have, like I said at the beginning, these three sort of things: our duty to the system, our duty to our clients, our duty to ourselves. And right now, as always, there's going to be a group of people, that 16% for whatever reason, who are not going to want to be compliant. And so let's talk about them and how we deal with them. So we have the wonderful thing of Circular 230, and I know you're all familiar with what this is, and so I won't, I hope you are. I won't bore you with it, but these are really the regulations that govern our practice before the IRS. And over time, the Treasury has tried to add to Circular 230, and then they've had to pull it back. Or they've added provisions that courts have determined to be unenforceable because they've exceeded the scope of their authority. So Circular 230 itself, when we go through some of these positions, there is an open question as to whether all of these provisions are enforceable, right? If you violated one, whether anyone would actually be able to do anything to you about it under Circular 230. Now, you have to keep in mind that a lot of the provisions of Circular 230 have matching code provisions. So even though maybe your conduct wouldn't be subject to discipline under Circular 230, it maybe would be subject to a penalty under a code provision or a criminal prosecution. But when I think about Circular 230, I put all of that aside, and I just pretend in my mind that it's enforceable because it just makes it so much easier, right? If I did run afoul of it, would I rather have just complied, or would I rather argue with the IRS about whether a particular provision is enforceable, right? I'd rather just never do that, right? And so Circular 230 to me functions somewhat like, I have a teenage daughter. Faye and I were just talking about her college choice before we started tonight, and I sometimes say to my daughter, if there's something that you're not comfortable doing, like with, your friends are out and they're like maybe drinking more than you're comfortable with, or there's something going on, you don't want to go to a party or whatever, and you don't want to be uncool, you can just say, whether I know about it or care about it, my mom won't let me, or my dad won't let me, right? That's Circular 230. Use it for that. You can say, I hear what you're saying, why you want to take this position on the return, or why you want to take this position during the audit, but we can't. Mom won't let us. And Mom is Circular 230. It tells us what we can and cannot do. And it's wonderful to have that guidance, because it really takes the judgment and the stress off of you to make these hard decisions. It tells you exactly how to counsel people on all kinds of issues, what you're able to do when you're interacting with the IRS and what you're not. And it really provides you some comfort so that you can go through your day knowing that you're serving the 3 goals. What you're doing if you're complying with Circular 230 helps the system, it helps your client because it keeps them out of trouble, and it helps yourself because it gives you the ability to put your work down at night and know that you haven't done anything that's going to come back and haunt you in a year or two when the IRS sees it. So my poor students who are here have heard this once tonight, but this is the origin story of Circular 230, and it's kind of interesting and it's kind of fun to think about, because what happened in 1884 that caused Treasury to promulgate Circular 230 continues to happen. We never change, right? People are the same decade after decade. So what happened with the Horse Act is that during the Civil War, both the Union and Confederate Army would go around and they would take people's property, primarily horses, to use in their own war efforts. And they would not compensate the farmers or the private people that they were taking the horses from. So after the war, the Treasury decided the fair thing to do would be to compensate people for the loss of their horses. Now, thinking about that time period, you wouldn't have had the same communication we have now. You would have lower levels of literacy and education. And so what some enterprising folks did is they acted as agents. They said, I'll go around, I'll ride around the country, and I'll talk to all the farmers, and I'll let them know about the Horse Act and that they can get compensated if they had any horses seized by the armies. Great. Well, why? How do they get paid for that, right? We got our first contingency fees, right? They say, I will go and I will make your claim for your horses, and in exchange, you will pay me a percentage of whatever it is I'm able to collect on your behalf. So that creates a lot of incentives for fraud, creates a lot of incentives for false claims before the Treasury, because who's going to check, right? How are they going to know whether Farmer Brown really had 2 horses instead of 1 horse, or the value of that particular horse before it was taken? So this became a problem. There was a run on the Treasury, and so Congress acted with the Horse Act, and it created Circular 230, or created the law that allowed for Circular 230, which regulates practice before the Treasury and puts forth certain standards for your communications and representation and interaction with Treasury. And so, as I said, this kind of continues today. We think about, under the COVID disaster relief, they earned the employee retention credit, right? Great program to try to help businesses stay afloat during the pandemic. What happened? Agents went around, some tax professionals, some not, and they went around to businesses, because it is complex. It's not easy to do on your own. And they said, we'll do your ERC for you. We'll take a percentage of it. And what happened? We had, hundreds of thousands of false claims filed. IRS had to shut down the system. It's been a massive problem. And so even with Circular 230 on the books, people are still doing it. It's still a problem. There's still these time periods where we have these runs on the Treasury because there is some sort of benefit that people want to claim. And so, all of the reasons for the original enactment of Circular 230 still exist. And that's a little bit of the background. Some of you may remember some of the larger amendments to Circular 230. It's been amended a lot of times. The last change was in 2014 in order to walk back some onerous provisions, to put it mildly, on the rules for written advice and some other things. And then it's kind of sat as it is for quite a while. And then last December, the Treasury proposed regulations to amend Circular 230. And so that's been the first time in a long time. And so some of those amendments seem totally reasonable and fine, and some of them in the tax practitioner community, people felt like they went too far or they went in a different direction. But the public comment period has ended, and we're waiting to see if anybody takes it up at this point. And we're not really necessarily expecting it, but you never know. It could come out any day now. All right. So we talked about practice before Treasury is how this became, or representation before Treasury. And so here we're really looking at acts connected with representation before the IRS. And this is actually fairly narrow. It does not, despite Circular 230's own words, in 10.34 and other provisions, govern tax return preparation or advice. But we, like I said before, we just are going to pretend like it does so that it can be a guideline for us in having an ethical practice. All right, so these are some key provisions. Don't worry, we're not going to talk about them all. We're going to begin with these three because this is a way that we like to think about Circular 230, and these kind of being like the three pillars. Like that if you really think there's all these rules, it's a long set of regulations, but what's the core of it? What is it really getting at? And it's these three things: competence, diligence as to accuracy, and the standards for tax positions. And so we're going to talk a little bit about what each of these things mean. So competence. It means you have to have the necessary competence, to render advice or to do whatever task that you've been hired to do. And so competence, as it is defined here, the appropriate level of knowledge, skill, thoroughness, etc., for the matter for which the practitioner is engaged. And you can become competent. Nobody's born competent. Even Michael Schler, he had to learn. The code, new provisions come up, he has to learn those. He actually doesn't know everything. He can learn everything, though. We know that. We know that he can. We've seen it happen. But he has to take the time to learn it, just like everybody else, right? So if there's new code provisions, he's got to pull them out, he's got to read them. And so you have to be competent to know what, and to know your limits. And that's totally fine. I always say in these speeches, I am not competent to do a lot of the things that the people in this room can do with these. I am not competent to do your M&A transaction. Not going to happen. I am not competent to plan your, cross-border deals. Not going to happen. I know that. I'm not getting involved in that. I'm a tax controversy attorney. I'm not a planner. I'm not a transactional lawyer. Great. So don't ask me. Come later after you've screwed it up. I'll help you get out of penalties. I'll keep you out of jail, but I'm not going to plan your transaction, right? That's okay. I'm not embarrassed about that. I'm proud of it, right? I'm good at one thing. It is not all these other things. That is okay. And I think that especially for the younger members of the bar, it's hard to admit that you don't know how to do something and that maybe you're not capable of learning it. But really just admit it. Either become competent if you can, or accept the fact that we're all not good at everything all the time. Let it go. Refer it to a colleague. Don't get yourself stuck in a problem, right? Because when you start advising on things you're not competent on, what happens? You make mistakes, right? And then you have to figure out how to walk those back. So I think competence is a core principle of Circular 230, and so we always mention that. It's fairly obvious, but it gets forgotten sometimes because people want to please their clients or their senior partners or even just their own ego, and they're afraid to say, I actually don't know what you're talking about. So,
Megan, I have a
yes.
question, comment on that. I mean, it's actually pretty easy to do what you do, and what I did is to stay away from things we don't know about. When we're in a law firm or an environment where you can turn it over to somebody else, and the client isn't standing there breathing down your neck saying, you got to do this, right? But like I have some clients who provide advice to others. I'm not providing advice to the others, but the clients will call me up and say, well, I want to do this kind of thing. And they're in small environments where they don't really have anybody else. So if their client comes to them and says, I want you to do this, including all these aspects, let's say, of the deal, they're not really in a very good position to say no. Of course, they try to learn it. But I do worry that in some of these rules for smaller shops might be very difficult. I don't know if we have a...
No, I totally agree with what you're saying. And it is easy to say if you're saying it from a position of being a partner in a firm where you can pick and choose what you take on. You don't always have that luxury. You may need to take something, to keep your firm going. You don't want to send a client away to another law firm. They might not come back. So for those people, all they can do is their best, right, to find a way to develop competency where they maybe they consult with someone they know, they take some CLE classes, they they pull out the code and the regs, they work it through. They talk to their friends from their graduating class at the LLM program at NYU to see what they think. And so I don't think that they just have to be like, well, let's go, let's see what happens. They can obtain competency through study and consultation. That's the best that they're going to be able to do. Or they have to make the difficult choice of saying, we're going to co-counsel with someone, or I'm going to refer you to another firm, which is, tough. But again, I think all the times that when I have gotten ahead of myself and like said something before I checked it, I've always regretted it. And I think that it's probably the same for those people too. When they're in the mire of this mess that they've created because they really didn't know how to handle the issue that was in front of them, they regret it. They'd take it back if they could, to get out of it. So it is tough. This is an issue. And also, as the tax law becomes more complex, there's more at stake. There's, more penalties. There's more difficulty. It becomes harder, right, to be a generalist in tax and not to specialize. But again, Circular 230 asks you aspirationally to try to be competent before you take on a matter. Yes?
I like what you said. When you said, what you say to the client, I'll keep you out of jail.
Yeah.
Are you a criminal lawyer?
Sometimes I am. I do both criminal and civil tax controversy. Primarily civil, but I do some criminal.
That's part of the question that the tax inquiring sophisticated client say. Are you a criminal tax lawyer?
Mm-hmm.
AKA, are you going to keep me out of jail?
Yes.
Because you know the borderline.
I do.
I'm sure you know better than the average sophisticated litigator.
Well, and that's why we like to talk about this stuff with like a more broad group. I mean, I think sometimes people think about the ethics and penalty standards as being things that are more relevant to people who do controversy, but they're really not. They're most relevant to you all who are giving advice and planning transactions, because you're the ones whose advice is going to be considered later to see if it was appropriate or not, or a line was crossed, or if the client actually followed it or just ignored you and did something else, which is also an important aspect of a criminal defense in a criminal tax case. What the advice was and whether or not the client followed it. And so the front line on all of this stuff, the standards for tax positions, which we're going to talk about in a minute, that's all really the planners and transactional people, that really do need to know what kind of advice is appropriate and what kind of advice will get people into trouble. So we'll talk next about our other favorite topic, which is diligence as to accuracy. And so this also is fairly obvious. I mean, a lot of Circular 230 is kind of common sense, thinking about like what is best practice. And the diligence component is just simply to say that if you're preparing any kinds of submissions to the IRS or you're rendering advice, you should be diligent as to determining the accuracy of any facts you're going to be presenting or relying on, right? And so what does that mean? That, in order to ascertain the correctness, of any representation you're making to the IRS, like what do you have to do to be able to achieve that? Do you have to audit your clients? If your client tells you that they have a particular business expense and the amount of it, and that's a fact that's going to be used in your planning going forward, you have to go and check that. Is that necessary? And so the answer is maybe, maybe not. It really is a facts and circumstance sort of look at what's going on. And here we have a regulation, 6694 regulations are good. You probably all already know this, but 6694 is the penalty provision for preparers, non-signing and signing preparers. And so there is regulations around that talk about what it really means to violate those provisions or what the defenses are. And so one of them talks about, well, diligence. What does that mean? Like, can you rely on a client? Do you have to audit them? And it says pretty clearly you don't have to verify every piece of information, but you do have to you can't ignore the implications of information furnished to you or that you already know based on your knowledge of the world or common sense or your knowledge of facts related to that particular client. And you have to make reasonable inquiries. And so you have to keep making those reasonable inquiries and pulling at that thread until you get to an answer that's satisfactory. If you're not able to get there, you got to keep going or take a different path in the engagement. And you can't just sort of leave big questions on the table. And for us, it's always a red flag when we have someone who's maybe seeking our advice about something, and they tell us, well, we had a client the other day who said, for foreign trusts, I'll send one of you the trust deed on one of them, but you don't need to look at them all because they're all identical. I thought, oh, okay. But I said, why don't you send them all anyway? And my T&E partner looked at them and he said, they're not identical, right? They have very different structures and concepts in them, and whether that's really material or not to what we were going to do, remains to be seen. But again, you can't just take someone's word for it, right? Particularly if it's something easy like that. Yes, Mike.
Isn't the harder case not whether somebody spent some money or whether the trusts are identical, but whether they have a business purpose for what they did, and whether it's just a pure tax reason or a real business purpose, like you're applying economic substance doctrines?
Yes, right. And
much harder to evaluate it.
It can be. And Mike's question, if you all heard, is well, what about those kinds of tough questions, which are crucially important, especially these days, now that the IRS is finally pulling out the old economic substance penalty in audit, which they hadn't really done despite having lobbied for it. I think you just have to learn about it and you can't just take someone's word for it. A lot of folks got in a lot of trouble for just simply putting in a tax opinion one of the facts that formed the basis of the opinion that there was economic substance for the transaction without interrogating that. You got to believe it, right? And so how do you come to believe it? It's by asking questions, understanding the economics of the transaction, both considering tax and not considering tax, all of those types of things, and really work through it. Because that's a representation, if you're going to let the client make and you're going to rely on it, that you need to have tested to some extent. Is it ever going to be perfect? No. You have to make reasonable efforts, right? If the client tells you something that's incorrect, but you believe them, and it was a credible story that didn't raise any red flags, no one's going to fault you for that. It's where you're not inquiring or you're ignoring the implications of things that should be obvious in their face. Yes, Patrice.
So when you're thinking about whether something the taxpayer did is reasonable, you're allowed to take into account their level of education and sophistication, right? And I always wonder if I'm allowed to do it for myself too. So for example,
but you're very sophisticated, so.
well, thank you, but maybe not. But also when it comes to finance and tech, right? Someone could tell me they have a valid business purpose for a crypto choice, and I could just smile and nod, but I'm not confident to really understand that. And so I wonder, does that get taken into account in deciding whether you've done sufficient?
Yeah, I would think it would, and for yourself, you'd want to. It's I guess where competence and due diligence are sort of meeting, right? Which is if you're not able to understand your client's business because it's involving some technology you don't understand or cryptocurrency, and some of those different crypto offerings can be really difficult to understand how they function in real life. That is something, right, you'd want to talk to the client about, and maybe they can explain it to you in a way that makes sense and is logical and is credible, and you can go from there. If not, and again, it's talking to experts, reading to the best of your ability to be able to understand. Yes?
Yeah, there's some situations that arise where a client is going in a direction, and most likely is going to do something, whether you tell them not to do it or not.
Mm-hmm.
And to avoid creating willfulness or delusions of willfulness, I would say, I'm not sure you want to ask me that question. I'm not sure you want to go in that direction. You have any comment on that?
Well, if the client says, don't ask me that? Or you tell the client, don't ask me.
Say to the client, and the client would sit there and look and say, you're right.
Mm-hmm. I think what you have there is some sense that something's wrong,
Yeah, you have it.
you're not pressing them to tell you. And I think then what happens next, if let's say this is an important fact in the advice you're giving, then I would say you have to
give
get.
some advice on that question.
Mm-hmm.
And then it might be like 3 points, and
Mm-hmm.
two of them, and one of the third.
Right.
Because I don't want to make the client too educated,
Mm-hmm.
which creates a strong willfulness issue,
Right.
where I think he's going to do something wrong. So I'll just say, I'm not sure you want to ask me that question.
But right, and you could give them that warning, I suppose. But don't you want them not to do the thing that is you're concerned about?
There are times in your life where you know which way things are going.
Yeah.
Well, this doesn't happen every day, but it has.
Mm-hmm. Yeah. No, I think that if you're going to give advice based on a situation where you think something's wrong and you're kind of like deliberately not hearing what it is in order or not talking to the client about it in order to avoid the issue, that's probably out of compliance with Circular 230. However, if the client is like, fine, that's not what I want to, it's not what I'm here for, right? You don't have to police every aspect of their life. If there's something else that's got nothing to do with what you're handling, then, I suppose so. But I think that, if someone's sitting before you and they really do have some sort of criminal liability or they're about to do something, I think it's okay to try to help them not do it. Because it is, everyone regrets it. No one ever at the end of the day says, I'm so glad I got prosecuted for tax evasion. Yes?
Yeah, well, I think almost all of us have been in that
Mm-hmm.
wild zone in between what the gentleman
Yeah.
is inquiring or mentioning and what you're lecturing about. And why bewilderment is, what do you do when the client says something to you that appears, word for word, quote unquote, appears to be incorrect or incomplete? How far do you go, and at what point do you
Mm-hmm.
send something to them in writing to prove that you said, don't do that?
Right.
But you're implying, and he's running away from both
Yeah.
of which are intelligent.
It's such a good question. Yeah. And when we get to the point, we're gonna we may or may not make it there. But when we talk about standards for tax return positions, one of the issues is that if you don't have substantial authority, but you have a reasonable basis, you can make an adequate disclosure, right? And you may advise the client to make the adequate disclosure, and they may choose not to take that advice, which is fine. That's their choice. But then what do you do? Are you going to memorialize that and send it to them? Or are you just going to have a conversation and note it to yourself, right? And so that is such a difficult question, and I think it's a really case-by-case judgment call of your feelings about the client, whether they're open to taking your advice or not, what they might do in the future, and how that might come back to you. So on a lot of those types of things, like whether you have to put something in writing, if you know the client's not going to follow your advice or not, that's going to be not covered by Circular 230. There's no rule about it. It's just your best judgment. But the main thing is that if someone says to you, can I do this? And you know they can't, you need to say no and explain why, right? And whether and how you memorialize that is a different question that's outside of the ethics rules and more in just sort of the tax practice management world. But it is something that people struggle with. And I struggle with it too. I mean, one of the things that we experience doing tax controversy is a lot of the people we've met are in that 16%. Like the people who come in are the ones who, not 100%. A lot of our clients have good faith disputes with the IRS and they've not tried to cheat in any way, shape, or form. But there is that 16% that come in and, they're constantly trying to get you to join the criminal conspiracy, right? By perpetrating false representations to the IRS or continuing to commit tax evasion. And one of the founding partners of my firm, whom I never had the pleasure to meet, but one of the things we remember about him is one of the great things he said. This is Jules Ritholtz, one of our founding members, and he said, always remember Rule 1. Does anyone here know what Rule 1 is? I bet you do.
No.
You don't?
My Rule 1 is watch my ass.
Exactly.
Is that Rule 1?
That's Rule 1. I'm going to say it in a little different way because I'm going to say it like Jules Ritholtz said it, but it is the same concept, which is if somebody has to go to jail, make sure it's the client, right? And so that's, keeping that in mind. Not joining any criminal conspiracies today. If someone's talking to me about wanting to do something that I know don't meet the standards for return positions or the standards for interactions with the IRS that we're talking about, we're not going to do it, it's not worth it. Nobody's paying a big enough fee, right, for that level of service. So, getting into diligence again, you got to ask the questions. You got to make sure that what people are telling you are credible before you base advice or base representations on it to the best of your ability, a reasonableness standard. Doesn't have to be perfect or scorched earth, but you got to make an effort. Yes.
I guess that in the context of national context, this will make sense. But if we're doing cross-border investment, this can get really muddy.
Right.
Because I can give you an advice, and let's say a year later, our structure is in place, and you get audited because it's cross-border. You get audited by one of the tax administrations, and you get it in trouble. It's not because I was a company or I didn't verify the information. It's because probably something went wrong.
Right.
So is this the same in a cross-border situation as because some tax lawyers just deal with cross-border, and sometimes you don't know if it's going to go wrong. It just happens that.
Right.
I gave you the advice to the best of my ability, but it happens that the tax administration, or in the case, I'm thinking in the case of MAP procedure, which is different competent authorities arguing about an issue, and they figure out, oh, what you guys did were wrong. But I gave you advice, and I thought that it was the best advice that I could give.
Right. Yeah. No, so the question is talking about cross-border transactions where there's like an element that's like going to be hard to understand and perhaps beyond your control, right? Because of the things that are happening in other jurisdictions where you may not have expertise. You may be relying on non-U.S. lawyers and non-U.S. advisors and clients to provide information. And then, yeah, if you have like the map and you're going to competent authority and they say you're wrong, what we're talking about here isn't that you're guaranteeing an outcome or that you're getting to a perfect standard. What you're doing is Circular 230 Light guides you to make your best efforts. So I'm sure that when you're working on those types of transactions, you are making your best efforts, right? You're making your best efforts to be competent and understand the subject matter you're working in. You're doing your best efforts to be diligent, to ask those non-U.S. lawyers for the information you need so that you can work with them to render advice. And we're about to get to standards for return positions. You're trying to meet that standard. If the IRS or the other taxing authority doesn't agree with you at the end of the day on that, that's okay. That happens. That doesn't mean you acted inappropriately or unethically. It just means, sometimes, there's good faith disagreements about how the laws work or how the tax law works. And now that's a good segue into talking about the standards. We'll just jump to that so we can have time to get to it. Which is 1034A has the standards for tax return positions, which match 6694. And they also matched the AICPA standards of statements on standards for tax services for CPAs. They also match the taxpayer standard for substantial understatement penalties under the code, under 6662. So we've got this sort of uniform view of what is a reasonable tax return position. And it is one that is either supported by substantial authority or has a reasonable basis and is adequately disclosed. And so these are a lot of words, and that's basically what it's saying. And so we look at this, and this is just sort of the breakdown, which is what I just said, and it said more simply as to what the standard is. So in your example, if you're meeting that standard, and the IRS disagrees, or the French tax authority, or whomever disagrees, that's okay, right? Because as we're going to talk about, reasonable basis is like a 1 in 3 chance of getting it right. Right? You're not out there guaranteeing a tax outcome. You're saying, based on objective factors, we think that this is not an unreasonable position, right? That someone might agree with it someday. So we'll talk about this quickly. So substantial authority, as you all probably know, is like defined in the regulations as authority that is substantial. So thank you, Treasury. But what they're saying is, of primary sources like the code, cases, treaties, IRS guidance, regulations, etc. If based on those primary authorities more are in your favor than are against you, then it's substantial. And this could also be facts. It's even though the regulation doesn't say it, courts have consistently held over the years that substantial authorities can include facts. And what do I mean by that? I'll give you a silly example, but it's an example that makes the point come home, which is the hobby loss rules, right? We know them. They've been in the regs forever. There's no doubt what they mean. I mean, there may be some fringe arguments about interpreting them, but they're black letter law, and they have been for a long time. So if you have your horse business, which is always the subject of hobby loss cases, right? There's thousands of them. Why? Horses are fun, but they're expensive. So you say, okay, I guess we'll have some writing classes, and then we can deduct all of the expenses that are related to having this business. IRS doesn't like it. They come and they look at that. So how do you have substantial authority in that type of situation? We know what the hobby loss rules are. There's no arguing about it. You know, the IRS has got the upper hand on what those mean. There's no gray area. There's not like some cases that say the hobby loss rules are X and some cases say that they're Y. No, they're all the same. So that's what you're getting into the facts. So you look at your facts and support that you have a business purpose and a realistic expectation of a profit in this horse trading business, and you can then compare that to all the other cases where the courts have found that existed, right? And so your facts compared to other facts can be substantial authority. So this test isn't always just about, well, we have a reg and the IRS has a case. That's pretty rare, right? It's usually looking at what we agree the law is and then how the facts fit into it. Although there are circumstances, and it comes up, right, as we have new legislation or new guidance issued, where there may be actual questions about the interpretation of the law, whether the IRS and Treasury are correct or whether the taxpayer is correct. And there you're going to be looking at the authorities in favor and against to the extent that they exist, or reasoning based on authorities that are analogous if nothing exists at that point yet. And so that's what you're looking at for substantial authority. Then you get to the point where you may not reach that, right? Because there's uncertainty in the law, or the taxpayer's position is just a little bit more aggressive, or it's operating in a grayer area. And that's where you're going to be looking at the reasonable basis standard, which is that there's some authority in support of the position. And that authority is the same set of sources that's listed in the substantial authority regs, right? The code, regs, cases, etc. And so as I said before, it's interesting, right? And I think it's kind of shocking when people first hear about what the penalty standards and the advice standards are, is that you don't have to think you're right. You just have to think you got a shot, right? That your argument isn't frivolous. But if you are kind of at this lower level, you know, in the maybe 1 in 3 area of reasonable basis, got to do one more thing, and that is to make the adequate disclosure. Yes?
I think a lot of people rely on 1 in 5.
Yeah, yeah. Well, I mean, the way to think about it, and you may be right, because like there's all kinds of like, you know, how many angels dance on the head of a pin kind of idea of like, well, how sure do you have to be to meet reasonable basis versus substantial authority? So if you have a more likely than not opinion, right, that's 51%. Somewhere beneath that is substantial authority. Somewhere beneath that is reasonable basis. And then below that is going to be frivolous. So, you know, you could say 1 in 5, you could say 1 in 3. But the key is you're not certain. You're not even 50-50. You think you'll lose, right? But you are permitted under the ethics rules to take that position anyway, right? You got to love America, and so. But if you're going to do it, totally fine, right? If it's in the client's interest and you have a reasonable basis, you got to make an adequate disclosure. So how do you do it? It's awkward, and this is always kind of a fun thing to ask everybody, which is, why do you? And I know you know what the answer is. Why is your client not going to want to do it? Why do they not want to add that form to their return describing their position?
Because they think they'll lose.
Well, that they'll get audited, right? They think they'll get audited. What do you think? Do you think the IRS looks for 8275s? That's the disclosure form. It's the next slide here. This fun form that describes tax return positions that only have a reasonable basis. Do you think the IRS looks for those and then audits those returns? Who thinks so? Who thinks that's happening? Who doesn't? If you were the one designing these rules, would you do it? Would you look for them? Yeah. See, wow, you guys are really law and order. I would not, because I would not want to punish people for complying with the law. I would say, look, you did the thing we asked. We're not going to target you. We're not going to give you necessarily a bad outcome. I don't know the answer. Yeah, I don't know the answer. I know anecdotally from asking rooms of people, so I'm about to ask you all, how many of you in your tax practice have recommended that someone's filed a form and they've actually done it? Anybody? And did they get audited? You don't know? No? See? There you go.
I thought that part of the reason for this disclosure was so the IRS could learn what's going on out there. They might decide not to go after that particular tax, but they do read. I thought they did read them so they could get a sense of what kind of people are doing.
I don't think they do. I think they read the reportable transaction statements. I don't think they necessarily read these. My understanding, and again, this is as you all probably know, the IRS does not release information on how it selects returns for audits, right? For good reasons, because of our 16% friends who will plan around it, and they'll find other shenanigans to get into that won't get them audited. So we don't really know, but looking at it from just, being in this field for a long time, it does not appear that they use it to select returns for audit. But of course, if your return happens to be selected for audit, they're going to read it and they're going to ask about that issue. So the way we talk about it with people is it won't necessarily generate an audit. It might. You might also just be unlucky. But it will cause them to focus on that issue. But that's okay, right? Because if they disagree with the position, you're already under audit, but now you have your penalty protection because you've made the disclosure.
No,
And
but
it's the law. Yes.
Yeah, but if it got out, and maybe it's already out that the IRS doesn't look at those forms, that just encourages people to take aggressive positions and file the form and not worry about penalty.
Yeah. Well, but you have to still have reasonable basis, right? And so just
But it's
filing the
not
form.
aggressive
Yeah.
position, it's 20%.
Yeah. No, it's true. I mean, look, the audit rate right now is like less than 1%. I don't know what to tell you. Attaching a Form 8275, it doesn't seem to change the outcome. Some people and companies are going to get audited anyway, regardless of whether they have the form attached. But when we talk about this with people, that's kind of not the point. The point is you're required to do this if you're taking a position that's not supported by substantial authority. The taxpayer is required to file it if it's necessary. And I want to go back a second and just say this RevProc has been updated. There's a 2026 version of it, so I apologize for that. But not everything needs to be disclosed. So before you go, scorched earth with your client on whether to file the Form 8275, take a look at the RevProc because it may not even be necessary. Like, for example, treaty-based return positions, you got to fill out a form. You got to, say a lot of things. And that's enough disclosure to let the IRS know what you're doing. You don't have to file an 8275 if you only have a reasonable basis for your treaty-based return position. Great. So nothing to fight about and nothing to worry about. So that revenue procedure lists all the tax positions that the IRS treats as being adequately disclosed as long as you fill out the required forms. And there are a lot of them. So, that's a place to look first. But if what you're disclosing isn't on that list, then you do have to talk with the client about it. And what you're required to do under both 6694 and Circular 230 is to advise the client to include it. And then it's up to them. Yeah. All right, we've got a couple more minutes left. I wanted to talk about two other things very quickly, and then I'll let you go for drinks. Let myself go for drinks. Audit lottery, right? This is a hot topic right now because we've got IRS workforce reductions. They're decimated. The budget's being crushed again. However, maybe with AI and other technological advancements, they'll become more effective and efficient. Who knows? But you're not supposed to play the audit lottery. So all of our advice is supposed to be based on the objective standards for tax positions that we just talked about. It's not about, go for it, because they're never going to find it because they just don't have the resources to look for it. And that really is the crucial part of being the gatekeeper to the system, is that you say, I'm only going to give you this advice if we're meeting this standard, not with regard to whether we're going to be audited or not. We're going to think about it as if we're all sitting together with the IRS and they're looking at it. Are we meeting the standard or are we not? And if you keep that in mind, that helps. This doesn't mean you can't talk to the client about the audit lottery. It would be silly if you couldn't talk about audit rates. They can Google it. They can see the IRS prints out every year a full report of the number of returns audited at each level of income and each type of entity or individual. You can see it. You can figure it out for yourself. So the way to talk about it, though, is not to say that you can go ahead and take a position that's not supported by these standards because of the likelihood of audit, but you can say to a client, I think, reasonably, you're meeting the standard, so you can go ahead and take the position. And by the way, it's probably okay. They may not look at it, but if they do, we have our position in hand that's objectively reasonable, that's meeting these standards. And then I want to say one more thing, and we'll go, which is just the knowledge of the client's error or omission. Because I just can't leave without saying this, because it's my favorite topic, which is, in our system, there is no obligation to file an amended tax return or correct past noncompliance. It's wild but true. But yet, as Circular 230 practitioners, we are required, if we encounter an error or omission, to tell the client about it. tell them what their penalty exposure is, and then the best practice is to also give them tools to become compliant if that's what they choose to do, and to evaluate the risks for them of filing amended returns or taking other actions versus not doing so. And so that's also a part of an ethical tax practice, is if someone comes in and they say, I've done this bad thing, you help them figure out whether they want to mitigate it and how, and you also encourage them to stop the conduct and become compliant going forward. And so with that, I think I am out of time, but thanks for all of your participation. That was really fun.